Welcome to the November Jackson docket of the Tennessee Supreme Court. We're happy to have everybody here this morning. Also want to welcome those who are watching this on live stream on the court's YouTube channel. We're going to start our first case in just a moment. I would remind the appellant, if you need to reserve rebuttal time, please do so when you come up here. Mr. Hibner, you may call the first case.
Paul Zachary Moss versus Shelby County Civil Service Merit Board.
Good morning, Your Honors, and may it please the court. My name is Lee Whitwell of the Shelby County Bar. At this time, I would like to reserve 5 minutes for rebuttal.
Okay.
This is the second time that this case has reached this court. This time, the issue is simply about the level of discretion that the Civil Service Merit Board has to exclude evidence. We would submit that the Civil Service Board has broad discretion to hear or exclude evidence of disparate treatment against other employees in cases where the employee before the board does not allege an equal protection violation. So we would ask that the court reverse the Court of Appeals and find that the Civil Service Merit Board did not err in excluding Mr. Moss's evidence of what supposedly happened to other employees in other matters.
Other than equal protection, would we ever let any evidence in of that nature in a case like this?
Our position is that the Civil Service Board certainly has the discretion to do so, but that it's never required to do so unless the employee before it is alleging an equal protection violation. And I thought about that on the way up here and wondered when would be a time that the Civil Service Board might use its discretion to choose to include that evidence. And the best answer that I could come up with would be a situation where what the employee was accused of doing was very technical, something that maybe would make the Civil Service Board feel like it was out of its depth in figuring out whether just cause existed to terminate the employee. For instance, we have cases where employees have been disciplined before because they didn't appropriately record their leave time on the computer system. The computer system's very complicated. And in cases like that, you might see the Civil Service Board say, we can't tell whether this is a big deal or a small deal. Tell us what you've done in previous cases. That's not the case here, though. What Mr. Moss did, I think there's very little dispute that outside of what may or may not have happened to other employees, he violated policy to the letter. He committed infractions worthy of termination. So here we would submit that there was no necessity for the Civil Service Board to even use its discretion to include that evidence that he submitted about this other supposed employee.
But it is your position then, if you're being consistent, that had the board decided to allow that evidence in, that would have been within their discretion as well, correct?
It would have been within their discretion. Now, we would submit that no facts that he could have shown the board would have changed the outcome here. So it was harmless error either way. What he did, as the court recognized in its first opinion, was a plain violation of the Shelby County Fire Department's general rules of conduct. Not only his behavior at the rally, pointing a gun at people, starting a fight, all of that, but his dishonesty later on throughout the proceedings. He lied and got caught lying during his Loudermill hearing. That was a truthfulness policy violation. So he committed such plainly terminable infractions that even if they had heard this supposed sexual battery matter, and even if what Mr. Moss had been able to show was that some previous employee did commit sexual battery and was not fired for it, that still doesn't mean that Mr. Moss should have been able to keep his job.
Mr. Whitwell, I guess what's bothering me about this is a very unique set of circumstances here, but I'm worried about the precedent we set. What if you have two employees who almost committed the exact same set of circumstances or same offense, if you may, and then one is disciplined and 6 months later another one comes in with almost the same set of circumstances? Shouldn't that be admissible?
Well, again, I would say I think it should be discretionary with the board. And in a case like that, what I think the employee would argue is, this is not just me trying to go back through time and find some situation where something different happened. I got disciplined for this thing that this other employee didn't get disciplined for a month ago. And if he wants to make that argument, the board will hear the argument, and within their discretion, they can decide, well, that sounds like something we want to hear. But what the Court of Appeals did here is something that no court in Tennessee has ever done before in a non-equal protection case.
I want to clarify what we're dealing with here. The standard of review for an appellate court, for the Court of Appeals or for us, is not whether or not a particular evidentiary decision by the Civil Service Board is arbitrary and capricious. It's whether their entire decision in this matter is arbitrary and capricious, right? And it's not, I mean, the evidentiary decision that they made is one piece of it, but the standard of review, arbitrary and capricious, which is quite a high standard, goes to their entire decision.
I think that's absolutely correct, Your Honor.
Okay.
I think the Civil Service Board could certainly make some crazy evidentiary ruling, perhaps doesn't allow the employee to testify or something, that would be so far outside of the norm that it would violate due process. But when you have here a discrete instance of the Civil Service Board hearing the entire case and admitting some testimony into evidence and sustaining objections to the rest, I think Your Honor is correct. It doesn't change the overall outcome.
Civil Service Board is not comprised of lawyers, right? It's an administrative body
That is correct.
that is essentially looking at whether the termination has a valid basis or not.
That is correct, Your
Okay.
Honor. And to that point, I think it's important to note, I know Mr. Moss asked during the hearing if he could make an offer of proof and said, well, if you're not going to allow me to submit this evidence, at least let me make an offer of proof. But to Your Honor's point, this board is not made up of lawyers. They're essentially professional jurors. And so they know, they sort of know what they don't know, which is how to sort out what they're supposed to consider and not consider. So if they start to hear something that they think is getting into what they consider inadmissible territory, they're not going to allow an offer of proof. They will, and I think what happened here is the chairman said, that's something that you can take up on appeal. And there is actually a mechanism in the statute 45322 that allows the employee, or whoever appeals to the Chancery Court, to ask that the record be reopened in cases of procedural irregularities. So if Mr. Moss really wanted to get this evidence into the record, Chancery Court would have been the place to do it. That didn't happen here. Mr. Moss did not ask at the Chancery Court for the Chancery Court to use that 322 provision to hear more details about this sexual battery employee from the past.
Mr. Whitwell, if we agree with your position, would our decision here end this case? Are there any remaining issues other than this issue?
This would, in my opinion, effectively end the case, yes. What the Court of Appeals below said is the court only left this one issue, whether he should have been allowed to include this evidence. The court said, I think, in a footnote or near the end of its opinion, we're reviewing this question through the lens of the statute 45322 and the Davis versus Shelby County Sheriff's Office opinion, which is sort of the standard for admissibility of evidence or not. They said we're not reaching the question of whether this failure to include evidence would violate due process. So I suppose one could argue that the Court of Appeals didn't reach that issue. But I would submit that all of the case law that we have provided and that the opposing party has provided really encompasses the entire universe of this issue. Massey, Freeman, Lamar, Inquist, all these cases really show the entire body of law in Tennessee that exists on when and under what circumstances one can introduce evidence of disparate treatment. So we would submit that there's not really a separate analysis that would be worthy of a remand. And I think this court certainly doesn't want us to ask to come back up here.
Oh, really? Well, if we agree with Mr. Moss, then it would go back to the board for a new hearing with the ability for Mr. Moss to introduce this evidence of disparate treatment. Would that be correct?
That's correct, but,
Okay.
you know, in a danger there, one of the reasons that we thought it was so important to ask the court to take this up is that the Court of Appeals opinion, not only does it hold something that we submit no other court has ever held, but it also is very open-ended. It also gives very little guidance to the Civil Service Board about what it's supposed to do with this evidence. It doesn't say, if you find that someone else did commit a worse infraction in the past and wasn't terminated, Mr. Moss wasn't terminated. I suspect that's what Mr. Moss would argue, but it really doesn't give the board any guidance on how to apply disparate treatment evidence. And as to Justice Kirby's point, again, these are not lawyers. They're not equipped in the same way that the City of Memphis's judicial officers at their commission are to figure that out.
So is it your position also that by virtue of the Court of Appeals opinion, the Civil Service Board essentially would have to admit this type of evidence in every case?
I think that is certainly Mr. Moss's position. And I think one of the other things that the Court of Appeals opinion doesn't really flesh out is what are the parameters of that? How far back does the employee get to go? Can he submit a public records request for every discipline that's been issued to every employee in Shelby County? Can we go back 50 years? And you know, there's really not a lot of guidance there on how. Now, I will say the Court of Appeals opinion here said, do not limit. Mr. Moss is not limited to just the sexual battery case that he brought up. He can bring up other instances. So that's going to force the Civil Service Board to essentially hear the retrying of potentially dozens or hundreds of cases.
Does it make a difference at all here, Mr. Whitwell, that, as I understand it, I guess the reason this evidence was, that they sought to introduce the evidence was, at least in part, for impeachment purposes? Is that right? Am I right about that?
Well,
That it was, that, you know, there was a witness who was talking about, you know, the fact that, you know, they have this consistent policy that if this happens, you know, it's a terminable offense, and then he sought to introduce some, I guess, contrary evidence, in part at least, to discredit that witness or to impeach that witness. Does that make a difference at all? Or could that, is there, I guess, a case in which that could make a difference, the fact that it was for impeachment purposes and not necessarily to establish disparate treatment for the sake of establishing disparate treatment?
I'm not sure that I can say that it would never make a difference. I don't think it made a difference here. Because here, that argument that this was really about impeaching Chief Benson is really just a long way around to the same end game, which is that what Mr. Moss did, assault off duty, basically, was not terminable, that it was not sufficiently serious to warrant termination, contrary to what Chief Benson had testified.
So if the witness were instead, you know, someone who had also observed the incident that, you know, allegedly provided just cause for termination, then perhaps there would be, this is getting kind of convoluted, but I guess I'm trying to imagine a situation in which the fact that it was introduced for impeachment purposes might make a difference. But I take your point that here it really was one and the same.
Yeah. And the court has said that employees have the right to confront their accusers. So for instance, I think if Mr. Moss's counsel had been cross-examining Mr. Mayfield or Mr. Ezel about the events of that day and tried to introduce some evidence, you know, here's a social media post where you say, you know, this didn't actually happen, then I think you would run into a due process right. And so that due process right to confront your accusers sort of covers that gap there.
How do you define just cause? I mean, I take it from the earlier, I guess an earlier exchange, that you would agree that there are I guess there are some incidents that just objectively, no one could really dispute that they provide just cause for termination. And then there are others that, maybe it depends on how the employer has treated that situation in the past. Is that your position?
No, our position is that it is never necessary for the employer to show that they have in the past treated these instances this way. We could have a county, for instance, where for decades, some infraction has just been tolerated, and then new leadership comes in, or the same leadership decides, we've got to make a change, we've got to crack down on this, whatever the infraction is. As long as just cause exists objectively, the employer doesn't have to prove or even show that this is the way we've always done it. I think the best definition for just cause comes from, these cases are all named so poorly, it's just Knoxville versus Knoxville. One of them, Knoxville Utility Board versus Knoxville Civil Service Merit Board, which is a 1993 case that really goes through, and it cites to treatises and things like that. What does cause mean, and what is just cause? And the court there, drawing from those sources, said just cause is any reasonable, sufficient cause that would lead a reasonable person to find that termination is appropriate. And then the court followed up by saying that the most important consideration for just cause is what supports the public good. Here we're talking about firefighters. We're talking about people that come into our homes. As Chief Benson said, they're the people that see us on our worst day. We have to be able to trust them. The public good demands that we have to know that they are not going to lie to their supervisors about past altercations with police officers, that they're not going to put a gun in their pocket and go to a political rally, get into a fight, and then point the gun at people. So just cause is a very broad standard, and we would submit that it's really almost a legal test to be applied from one end of the state to the other, and that it's not a subjective test that grafts onto itself whatever that previous employer has done. This is necessary. We had elections yesterday. There's going to be a changing of the guard. There are going to be new leaders in a number of state positions. We had our own elections in Shelby County just a few months ago. Those leaders are going to come in and they're going to try to make changes, which is what the voters may have elected them to do. That guard changing function does not work if when the new leaders come in and say, we're cracking down on drug offenses. If you pop positive for a drug test, we're really going to start terminating for that. If the employees can just go to the Civil Service Board and say, the last chief did not require this, and I can show you 3 employees who got away with it, so I have to get away with it too. And then I'll just briefly, the only other 2 things I want to mention, one is harmless error, but before I get to that, there's really kind of a ridiculous argument that comes out at the other end of what Mr. Moss is saying here. What he's saying is, if the court, or if the Civil Service Board hears this evidence that this firefighter was not terminated for sexual battery, then what he's essentially going to go on to argue is no one in the fire department can be fired going forward for anything on the level of sexual battery. I committed an assault off duty. That obviously can't be what the just cause standard is about. The last point that I'll just raise briefly is the Court of Appeals did find in the alternative that even if that what the board did was not harmless error. And we would submit that if anything, that the board was not required to hear this evidence at all, that it has the discretion to exclude it. But even if this court were to find that the board did have some obligation in this non-equal protection case to hear this evidence, to go back to, I think, Justice Kirby's question earlier, it was only harmless error. It cannot, no amount of impeachment about this other employee who committed sexual battery can justify what Paul Moss did. And so even if all of that evidence had been introduced, we would submit, even if they had introduced evidence of a past employee who committed the exact same infraction, we would submit that it doesn't matter, that just cause still existed to terminate Mr. Moss, and that it was harmless error to exclude any evidence about other employees. If there are no further questions, we would ask that the Court of Appeals continue to reverse.
May it please the court. I am Mary Elizabeth Sanford. Mr. Clark is unable to be here today, but I did file a notice of appearance. I just want to start by saying it is an honor and privilege to be before you today. We would submit that the Court of Appeals was correct in its decision in determining that this matter should be remanded back to the board for consideration of disparate treatment. Mr. Moss was a longstanding Shelby County firefighter, and he was terminated in March of 2015. The substantial basis of the termination of Mr. Moss is based on conduct that has been expunged pursuant to the TCA statute. This criminal conduct that is the basis for the termination no longer exists. It's not part of his record. And so we would...
That doesn't mean it didn't happen, right?
And that's correct.
So how is that relevant, that it was expunged?
Well, we would submit that the main argument by Shelby County is that the basis for termination is just cause. And, you know, for our perspective, how can there be just cause when one of the reasons for termination was conviction of a felony? Well, there is no felony because those records were expunged. And so that, you know, is our position. The issue is simple here. There was testimony from Chief Alvin Benson, the chief of the Shelby County Fire Department, that he followed a uniform disciplinary process when it came to terminating Shelby County firefighters. And that process involved three things. One, was there a domestic assault or some type of violent activity that occurred with one of their employees? Two, was the employee the primary aggressor? And then three, was there a weapon involved? When he was questioned on that policy, he said that he applied it uniformly, he applied it fairly. And when asked about another employee who committed a sexual battery violation, which may not be the exact same as what Mr. Moss committed, but a similar violation, my co-counsel, Mr. Clark, was unable to continue questioning. And so the issue is simple. Shelby County is required to follow its own policies. There has been an admission that there is a uniform policy that is followed, you know, fairly and equally.
Ms. Stanford, if there was just cause to terminate this employee, what does it matter what the board would do with a different employee?
Well, the issue is, was the discipline discipline reasonable in light of the circumstances? And so our argument is, again, a substantial basis of the reason for termination was conviction of a felony.
But won't you agree the circumstances of this, I'll call it an offense, were pretty egregious? Alcohol, gun, elderly victims.
And that's one of the issues that's still in dispute here. One of the witnesses that was involved, that was one of the aggressors, was not even at the Civil Service Board hearing to testify. And so...
But that's not the issue before us.
Right.
The issue before us is simply whether the board erred by not considering the additional evidence.
Right.
Correct?
Right, and that is the only issue, and I think, Your Honors, you asked, if this, if you were to rule in Shelby County's favor, would this ultimately resolve the case? And I would submit that that is the only issue on appeal at this point.
Well, if I may interrupt you then, if that is the case, and if we were to affirm the Court of Appeals decision below, would we not be telling the Civil Service Board that they had to consider this type of evidence in every case? And if not, what are the parameters of where they would have any discretion as to whether they would be able to consider this type of evidence in a matter?
And what we're saying is that we do believe that it should be a requirement to consider disparate treatment evidence in every case, especially considering that this.
Are you sure that's what you want to say? That in every case, the Civil Service Board, it's not a trial court.
Right.
It's really an administrative court, sort of a belt and suspenders to make sure that there's just cause to terminate employees. That's what it's limited to. So are you sure you want to say that in every case they're going to have to go out into the hinterlands and relitigate 15 other offenses that somebody heard, somebody did, and well, now we need evidence and we need witnesses about all these other, are you sure you want to say that?
I mean, that's what the Court of Appeals rules, so.
That's my point is, how do we put parameters on that?
Right. And so here, again, we had an employee with a similar violation that we tried to address before the board and was unable to do so. And so I believe that since there should be some discretion, but in this case, where we clearly have a fire chief saying that, hey, I have this policy that I follow, there's a uniform policy, I follow it equally, I follow it fairly, that in those situations, there should be a consideration of disparate discipline when there's an actual uniform policy.
So if
What
you're
is-
saying
Go ahead.
No, so are you saying that if the employer is the one to sort of open the door to this or to point to a supposed uniform policy, that in that circumstance, the employee should be able to introduce contrary evidence? Is that
Yes.
what you're saying?
Yes, I would agree on that.
Well, has any case in Tennessee ever held that to be the law? Or would this case be making new law in that area in terms of requiring evidence of disparate treatment?
Well, there has not been any case that has required the evidence, but just as cited in the Court of Appeals opinion, there are numerous Court of Appeals cases that have remanded a matter back to the board for consideration of such evidence. And
But only in the context of an equal protection or other suspect class case, correct?
well, not just equal protection, but as far as
But
like.
some type of a suspect class.
Yeah, some type of suspect class, and I believe that Mr. Whitwell in Shelby County has cited in their brief the Holmes case that focuses on the equal protection argument. And we are not making an equal protection argument here. What we are making an argument on is that there is a uniform policy that has not been followed. And in that case, it was referenced that the disparate evidence could not be considered because of the fact it was an equal protection argument, and there was no argument about an internal policy that was violated.
Can you just tie your argument to the text of the statute that governs when relief may be granted in these cases? So, just looking at section 45322H, what is it about your uniform policy or lack thereof argument that provides a basis for granting relief from the board's decision?
Right, so it's strictly on the due process claim, just that the decision to not consider this evidence is arbitrary and unreasonable, and Mr. Moss should be able to present this evidence to show that, this was not fair, and that he was not allowed to introduce evidence that there was unfair treatment.
But how does that make, I guess, the board's ultimate findings and conclusions arbitrary or capricious? Because we're not looking at, as Justice Kirby pointed out earlier, it's not that we're to look at every single ruling in the
Right.
course of the administrative proceeding, like every evidentiary ruling, for example, and determine, well, was that one wrong or was that one not? It's that we look at sort of the overall proceeding.
Right.
So how does your argument, I guess, tie into that analysis?
And I guess with that analysis, with the overall proceeding, Appellee was not able to get into the evidence that shows that there was unfair treatment or issues of disparate treatment between him and other employees. And so due process would require that this evidence be introduced. And just because, Shelby County is asserting that there's just cause to be able to terminate Mr. Moss, that does not keep them from, preventing us from being able to present evidence that would suggest that discipline is not reasonable in light of the circumstances compared to other employees.
How does that make the overall decision? Arbitrary and capricious means there's just, it's nonsensical. It's a very high standard.
Right.
Mr. Moss was a firefighter who was pointing a gun at people and lied about various things in his investigation. Looking at the overall decision, even if you would have wanted to put in that evidence, how does it make it nonsensical for them to fire somebody who does that? That's the essential issue that I would like to hear you address.
And with it being nonsensical here, it was arbitrary and unreasonable because you have clearly evidence that shows that someone who committed sexual battery, we have that evidence, was still an employee with the Shelby County Fire Department. And yes, that may be a bit different than assault and, aggravated assault with a weapon. But again, I recognize that, expungement does not mean that it didn't happen. But the substantial basis of the termination was conviction of a felony. And that is not true because there is no conviction of a felony.
Mr. Whitwell mentioned in response to one of the earlier questions that, allowing or requiring, the board to consider these past incidents would, in some ways at least, kind of bind the agency to a particular position. So, if they hadn't, let's say a previous administration, hadn't terminated for a certain kind of incident, that by virtue of requiring consideration of this evidence, they would kind of be stuck with that. Because if they decided to start firing, then, that would be kind of evidence of disparate treatment. So, what's your response to that argument? Do you disagree with that, or is there kind of a way to kind of put some limits on this so that it doesn't have that effect?
What we're saying is that, there should definitely be some parameters here. But we are asserting that if this is to be remanded back to the board for consideration of disparate treatment, that it isn't just limited to that one employee or just limited to going back 1 year. Like we would, expect that or request that not necessarily 50 years going back, but at least, 10 years before Mr. Moss was terminated. That evidence be considered.
So in every case, the Civil Service Board of Shelby County is going to have to look at all of its cases over the past 10 years to determine the treatment that was given to individual employees in those cases in every single case.
And I think what our...
Is that a yes or no?
We would say yes, and I think that our argument here is that disparate treatment evidence should definitely be considered in these types of cases. We're dealing with somebody's livelihood. And, you know,
Ms. Stanford, is it even possible to go back that far? What type of record is kept of the board hearings in Shelby County?
well, I know that Shelby County, they do have like public records requests, and they do keep those records on file. They're required to keep them. And so they do have the information. Now, whether they want to go search and look for it, that's a different story. But, you know, this information should be on file.
And how far back would it go?
I'm not 100% sure on how far back it would go, but we would request that it would go at least 10 years back.
Well, you do realize if we agree with your argument that these board hearings that used to take 2 hours are going to take 2 days now, right? Is that a fair question?
Possibly, yes.
So if you're successful, then it goes back for a new hearing to allow evidence of disparate treatment, possibly up to 10 years back of evidence. If you're not successful today, does this end the case effectively? Are there any other issues that are still out there other than this?
This is the only issue that's on appeal. I believe Mr. Clark has an issue. I did step in on this case recently. I'm a recent newly licensed attorney as well. So
when were you licensed?
in 2018, but I also went to California, and I was licensed there in 2020, so came back home. But
You're doing quite well for
Thank you.
a brand new lawyer.
Glad
Thank
you came
you.
home.
Yeah,
I'm glad to be back. I moved during COVID, so
okay.
Yeah.
We're glad to have you.
thank you.
So do you think there is, well, I guess we can look at the record, but there was a footnote regarding a due process claim, but are you acquainted with that or can take any position on whether that has to be resolved?
I know that there is an issue as far as, because we pursued Shelby County as well as the chief. And so I know that that was one of the issues too, if there was a claim against the actual chief of the firefighter department.
Okay, thank you.
Are there any other questions? Okay, thank you.
May it please the court, I would just first like to say briefly that I was thrilled to see that Ms. Sanford was here today. She was, I think the last time I argued this case before your honors, she was an intern in our office. And so she was not involved in the case at that time, but I was so happy to see that she was going to be here today. The only issue that I want to sort of clarify is to Justice Bivens' question about what should the parameters be. I don't think there are any parameters as the Court of Appeals opinion stands now. I think the Holmes and Eccles opinions provide the precise parameters, which is simply that if an employee actually has a colorable argument that they were discriminated against because of their status in a protected class, then they can submit comparator evidence. How far back can they go? How much time can they spend on it? I think all of that is already fleshed out in equal protection case law. So this court doesn't have to reinvent the wheel there. It's simply a matter of looking at what plaintiffs can do and what employees can do in these kinds of cases when they actually allege equal protection. If they don't allege equal protection, or even if they say the magic words, but there's no actual argument that they're a member of a protected class, we would submit that there is no right under due process, or as the U.S. Supreme Court recognized in Inquist, under the Equal Protection Clause, to bring in disparate treatment evidence. If the Civil Service Board chooses to hear it because of some unique factors in that case that cause them to think it would be helpful for them, then they should have the discretion to do that. But if they choose not to hear it, they should not be ordered to hear it and then ordered to figure out what they're supposed to do with it in a non-equal protection case. So based on that, we would ask that the court reverse the Court of Appeals below. Thank you.
Thank you, Mr. Whitwell. Ms. Stanford, thank you. May call the next